Hello, and welcome to Tea Time with the Jackson Center. I am Kristen McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center in Jamestown, New York. If you are a regular viewer, you will note a change of venue. I'm actually in the center today, as opposed to broadcasting from my home. So welcome to my actual world. Our guest today is Ruth Marcus, the deputy editorial page editor for the Washington Post, who has covered every major U.S. government institution, including the Supreme Court, Congress, and the White House. She also writes a weekly column. Ruth has been with the Post since 1984. She joined the national staff in 1986, and she has been writing about judicial confirmation battles since Robert Bork in 1987. From 1999 through 2002, she served as the deputy national editor, supervising reporters who covered the Supreme Court, Congress, money and politics, and many other national issues. Ruth is also the author of Supreme Ambition, Brett Kavanaugh and the Conservative Takeover, the definitive account of a pivotal moment in modern history that will shape the judicial system of America for generations to come. Ruth was also the Robert H. Jackson Lecturer at the Chautauqua Institution this past summer. Ruth, thank you so much for being with us.
Thanks for having me back.
So given your length of history in covering judicial nominations and those conversations, I want to sort of get a sense of how this current one stacks up against the other ones. Are there common threads that we tend to see in judicial confirmation hearings?
Well, for me, actually, the first one that I covered, this is really going to date me, was Sandra Day O'Connor in 1981, before I went to law school. But it really goes back to Bork, and Bork set the stage for the modern confirmation battle. He set the stage for the modern confirmation battle in terms of an almost what not to do for nominees. Because he needed to, because his background was had so many extreme statements in it, he needed to answer questions fully about what his views were. But that created its own set of problems. So for conservatives, Bork became a never again moment. And so they learned that they had been outgunned, outmanned, out-argued really on the Bork battle. They weren't going to let that happen again. They created, through the Federalist Society and associated groups, the kind of legal, organizational, and financial architecture to prevent that from happening. Democrats who did, looking at the results, an effective job on the Bork nomination, we could talk about the meaning of Borking, were never really again able to reprise that moment. And there's almost been a trajectory from Bork on of less and less information and less value that we can extract from these hearings. And I think the hearings that we just went through with now Justice Amy Coney Barrett, and I'm still getting used to that along with the rest of us, really showed the limits of what these hearings can do. Every time a hearing rolls around, I dig out a quote from Justice Kagan before she was Justice Kagan, talking about the charade and hypocrisy of Supreme Court nominations and the uselessness of it all. And I argue that there is still some juice to be extracted from what they won't answer, the way they won't answer things, or whatever, but it's getting harder and harder. The thing that was most striking about this last confirmation, of course, was both the stunning speed of it and the late in the presidential electoral cycle timing of it. I don't think in 1987 with Bork, in 1991 with Justice Thomas, or even with Justice Kavanaugh or Justice Gorsuch during the Trump administration, that anybody would have believed that you could get through a nominee this close to Election Day. But it turns out if you're Mitch McConnell and a Republican Senate and you've got this vacancy, you can, hence Justice Barrett.
Well, and the length of time it takes to go through this process for a pending justice has ranged widely in over the entire course of the Supreme Court. Justice Jackson, for example, was also nominated and confirmed within 30 days. That tends to not be the trend in our modern era. But it's not as if this was a completely unique circumstance from that timing perspective.
I do think that I think it's comparing, I'm not going to come up with a good analogy besides apples and oranges. It's like, it's a different world that we are living in now with judicial nominations than with Justice Jackson. I would think that he was confirmed rather handily.
It was a voice vote even. So yes.
Okay. He probably didn't have a confirmation hearing.
He did not.
Right. So different world. I mean, even and the world has changed, even in the time that I've been a part of it. The notion of a Justice Scalia being confirmed 98-0, of Justice Ginsburg being confirmed, I think 96-3, that is never going to happen again in my lifetime, or maybe ever again. That is not where we are. And so the argument that the point that you make, which is obviously a true historical point, that Justice Jackson was confirmed within 30 days, it's a different world, because Supreme Court nominations, and certainly it's we know from the period that Justice Jackson lived in, that the Supreme Court could be kind of a pretty big deal and kind of a pretty big political football. So in that sense, we're reliving some degree of history also. But the poisonousness, the ideological nature of Supreme Court appointments, the stakes of them have all gotten so enormous. Just to give one small example, during the Bork battle, when People for the American Way ran a very small, in terms of the scope of the buy, television advertisement narrated by Gregory Peck attacking then Judge Bork, this was just viewed as using a nuclear weapon in a Supreme Court battle. Now, of course, the minute you have a vacancy, you've got millions and millions of dollars on both sides on the airwaves. It's a different world that we're living in now.
Well, and you bring up a good point. So there's always part of these teas is to help educate our audience. And I think one of the questions that certainly, I mean, not just with Justice Amy Coney Barrett, but came up with, people still have that 60 number in their head of you need 60 votes in order to approve a justice. And what you actually need what you used to need 60 votes for was to end the debate, to move on to the confirmation process. And Mitch McConnell did away with that in 2017, I believe. So you needed just that simple majority of 51 in order to end the debate and actually move on to the vote.
So this is like war in the Balkans, right? And so or the Mideast, conflagration in the Mideast. Who started this war is going to be argued by the partisans in it for decades. So a conservative or a Republican listening to your discussion of that history would say, whoa, wait just a second. We didn't start it. They started it. And they would have a point. Mm-hmm. Here's what happened. During the Obama administration, when Democrats were in control of the Senate, then Senate Majority Leader Harry Reid exercised what's known colloquially as the nuclear option. It's the ability to change Senate rules simply by a majority vote. It usually requires more than that. I think it's 2/3. And he used the nuclear option to lower the threshold for confirming lower court judges and executive branch nominees from 60, as you say, to 50 or 51, depending on whether you've got the vice president of your party there. This was, I thought, a bad and dangerous idea at the time, because for two main reasons. The first is it encourages presidents and partisans to pick more extreme judges of either flavor. And also it was 100% predictable that when push came to shove in 2017 and Democrats who were infuriated about the stealing of the Merrick Garland seat, the refusal to even have a hearing for Merrick Garland, when they filibustered Neil Gorsuch, very predictably, the nuclear option was deployed, as could have been expected, to lower that number for Supreme Court nominees. This is a very bad development because if you needed 60, if you continued to need 60 votes, you would have different nominees than Neil Gorsuch, than Brett Kavanaugh, and then Amy Coney Barrett. They would not be as dyed-in-the-wool Federalist Society, original intent, original public meaning, textualist conservatives. You would be able to extract more information from them if you were the Senate, because you would say, hey, if I don't, there would be more, more senators whose votes would be up for grabs. But that's not the world that we're living in. Why we're not living in that world depends on whether who you think cast the original blow and created the first sin, because to the Republicans who say, wait a second, you guys acted badly first, the Democrats would say, wait a second, you guys were refusing to fill seats that were open. You weren't confirming any of our nominees. Now you're busy ramming them through, but you wouldn't let any of our guys get confirmed, so you forced us into it. Anyway, and that's the story of the filibuster.
Yep. Well, and if I remember correctly, even at the time, Mitch McConnell was the Senate minority leader and told Harry Reid, you're going to regret this sooner than you think. Yep. So
he did. And Mitch McConnell is one of the best tacticians in the Senate, and he is capable of seeing around corners, and this corner was coming. What Democrats would say to you'll rue the day is, if we didn't do it, you guys would have done it when it was your turn, and you did. So at least they got a number of, before Mitch McConnell took over the majority and really shut things down, they got a number of significant, promising, really well qualified and highly respected judges named to the DC Circuit and other federal courts that they wouldn't have gotten otherwise.
Do you foresee a time when that threshold might be raised again? Or do you think at this point that ship has sailed, and the likelihood of it going back up to 60 or even 55, something that would require a little more bipartisanship, ever being an option?
I am not in an optimistic mode about bipartisanship, civility, all the things that I like to write about and call for in Washington. I don't do that anymore. I think if anything, what we're going to see if former Vice President Biden is elected on Tuesday is a significant push for, if there is a Democratic Senate that's elected along with him, to eliminate the filibuster for legislation as well as for judicial nominations.
Oh, interesting.
By the way, it was a good idea to eliminate the filibuster for executive branch positions, but that's a different story.
And maybe at some point we'll talk to you about that as well. So as you mentioned, so Justices Gorsuch, Kavanaugh, and Coney Barrett have all had fairly close votes. I think 50 to 48, 52 to 48, and 52 to 48. I might not have that order quite correct.
I think with the Kavanaugh vote, we had two senators missing, so it didn't add up to 100.
Right. Thank you. Yes. Does that tell us anything? Does that closeness of vote indicate anything other than these are fairly partisan decisions?
There is no reason that they need to be this partisan, but these have become very partisan decisions. They were probably there and heading there before we got to the point of eliminating the filibuster. I mean, if you look at the votes on Justice Kagan and Justice Sotomayor, for example, versus the votes on Justice Ginsburg, significant diminution of Republican votes for those two judges, and hard to really argue when that there's a significant difference among the three of them, though when she was named to the court, Justice Ginsburg was viewed as a moderate, though she's not viewed that way and has not been viewed that way for a number of years. But Republican votes were hard to come by even before, or votes from the opposite party were hard to come by before. They're going to be vanishingly small, though it is important to note that Justice Barrett is the first justice in some number of years, really a lot of years, to be confirmed without a single vote from the opposite party. That's unfortunate, but I don't blame Democrats either on the merits or on the procedure, because I would think that somebody like Senator Manchin from West Virginia, who was willing to vote for Justice Kavanaugh, would appropriately balked at the notion of voting for somebody 8 days before an election.
Got it. And do you think really the timing of this from the Democrat side really is what played into not a single one of them voting in favor of Justice Barrett?
Oh, well, I mean, if this had happened in July, would the answer have been any different? Maybe there might have been one or two up for grabs. I mean, there's not some kind of magical. I believe two things simultaneously that might sound contradictory. I think it was outrageous not to have a hearing and a confirmation vote and a confirmation of Merrick Garland after Justice Scalia died in February of an election year, because that's a really long time. And I believe was outrageous. And this is not a substantive determination, but it was outrageous to push Justice Barrett through to confirmation when people were already voting. The hypocrisy between those two is huge, but they're equally wrong, actually. The hypocrisy is just kind of icing on the cake for me. But there is no magical moment, right, at which all of a sudden, it's not certainly not in the Constitution, right, the president, in July or August or who knows, becomes constitutionally ineligible. It's just it when you see it. I do think that under these circumstances, people are so furious with each other. Republicans believe vehemently and passionately that not only was Bork borked, but Kavanaugh was Kavanaugh'd, and he was terribly smeared, and Justice Thomas, for that matter, was terribly smeared, and they're waging that battle. Democrats are waging their battle over the failure to confirm Merrick Garland to the Scalia seat. So there weren't going to be a lot of votes up for grabs in July or August or September, or name your calendar page.
Gotcha. Well, and I think one of the things we as the public tend to focus on is whether or not the nominee is a conservative nominee or a liberal nominee, or maybe whether they were appointed by a Republican president or a Democrat president, as a way to understand what their judicial outlook is going to be. And there's a lot of conversations after the fact, and you alluded to this with Justice Ginsburg of, they became a lot more liberal as they were on the court, or maybe some become more conservative as they're on their court. So is starting out with the idea that they are a conservative liberal, or were appointed by a conservative or a liberal, is that an instructive way to view the court and how they're likely to vote? Or do we need to focus more on what that individual's judicial outlook is?
Well, kind of yes and yes. Absolutely the best way to tell, well, one of the best ways to tell, but there are limits to it that I'll explain, what a judge is going to be like is what a judge has been like. This is why in the aftermath of some nasty surprises, legal conservatives and the legal conservative establishment in the form of Leonard Leo and the Federalist Society very much balked at naming people to the bench who did not have a record on the lower courts. At the same time, when you're a lower court judge, you're bound by Supreme Court precedent. So you're not really free. I mean, they're not all the same and they're not automatons, but you're not as free to do what you would as you are once you get onto the Supreme Court. So yes, you should look most of all at a judge's record, but if you look, for example, and you could look a lot, Justice Kavanaugh had, I think, a 12-year record on the bench. That was a lot to look at, and it was really instructive. But it had its limits because he would always say, well, I'm a lower court judge, I'm bound by this. Justice Barrett had only 3 years worth of opinions, so some of them were quite interesting, in particular on gun rights. But it's also true that this notion, it is so much less true now than it was 20 years ago that you're going to get these justices who are surprises. I did mention that there was some angst on the left about Justice Ginsburg. There was even angst among, people are not going to believe this, among women's groups about Justice Ginsburg, because while they understood that she was a supporter of abortion rights, she had actually questioned some of the legal underpinnings of Roe and whether it had been correctly decided, not in terms of the outcome, but doctrinally. And they were worried about her, but everybody understood who she was and that she was going to be a justice on the liberal side. But there have been many more surprises, and this is what we don't have anymore. I was just going through this for a column the other day, but if you look at the roster of Republican appointees over the last 27 years, because by the way, it was 27 years, no, that's not right, longer than that. It's been since 1969 that there has been a majority of Democratic appointed justices on the Supreme Court. Here's why that hasn't been as big a deal. Because the justices that were appointed by Democratic and Republican presidents were not as overtly and relentlessly ideological. They weren't chosen necessarily because of ideology. And as a result of that, they ended up surprising. So during that, during the last 27 years, Republicans have gotten, I think it's 15 of 19 nominations. That is a lot, but it hasn't been this overwhelmingly conservative court during all of that period because so many of those nominees surprised people. Justice O'Connor wasn't a liberal, but she was a moderate swing justice. Justice Kennedy wasn't a liberal by any means, but on certain key issues, he was a moderate swing justice. Justice Souter, who was supposed to be a home run for conservatives, turned out to be pretty liberal. And before that, you had justices like Earl Warren, an Eisenhower appointee, John Paul Stevens, a Ford appointee, and others who turned out to be leaders of the liberal wing of the court. We don't have that anymore. Ideology matters hugely in terms of nominating and choosing people. In particular, I think it's fair to argue on the Republican side, though this will be true of any pick that President Biden has. You would not see a Merrick Garland type nominee that I think the party would tolerate unless there's a Republican Senate and he needs to do something to get somebody through. By a Merrick Garland type nominee, I mean somebody who's rather moderate in approach. I think you're going to see nominees who are much more liberal if and when a President Biden gets the chance to do that. So we don't have surprises anymore. We have people with known judicial records, known alliances on the Republican side with the Federalist Society, known sets of writings, and they're not going to get nominated if there's not going to be as close as you can get to a guarantee that they'll perform accordingly, because the rallying cry was no more suitors. But right now, Republicans are so upset, I think their rallying cry could turn into no more John Robertses, which is crazy because the Chief Justice is really conservative.
Well, and we talked a little bit about that this summer as well as part of the Jackson lecture, and this actually leads into a nice segue, I think. So obviously, one of the main things that I think people know about Justice Barrett is that she is an originalist. much like Scalia. And I believe Gorsuch and Kavanaugh as well. And that one of the things we talked about this summer is that a conservative process can lead to liberal results, as we saw from Chief Justice Roberts this summer. But why don't we take a step back and sort of talk about the originalist? I think this is probably the first time we've had this large of a concentration of people who might identify as originalist.
Oh, 100% true. The concept of originalism, going back to the mid 80s, it was a little bit of a kind of quirky and not particularly well regarded concept when it was taken up by Ed Meese, who was Ronald Reagan's Attorney General, and by Judge Bork in academia, and then on the bench, and it was an element of his defeat. It was not seen as a kind of mainstream method of constitutional interpretation, but it has become, in fact, the main conservative method of constitutional interpretation, along with textualism, which is applying that same approach, what do the words mean of the statute in this case, to the law at issue. We talked about this summer, fascinating example of completely disparate outcomes dealing with the same text and using the same textualist approach in the case this last term at the Supreme Court about the meaning of Title VII and whether it protects gays, lesbians, and transgender employees or wannabe employees from being discriminated against. Answer according to one set of textualists, including the Chief Justice and Justice Gorsuch, yes, it does. Answer according to another set of textualists, the rest of the conservatives on the court, no, it doesn't. Same is kind of true for originalism. You can take an originalist approach, say, to the Second Amendment and come up with you may not understand really consciously that you're doing this as a judge or a justice, but you can come up with the answer that fits best with your kind of underlying philosophy.
Interesting. Is this going to change, given this concentration of originalists on the court now, is this going to change how arguments are presented to the courts? I'm even wondering, will it change perhaps how lawyers are educated in law school?
That's a really interesting question. Right now, the way arguments are presented to the court is really weird, right? Because we're going through this COVID telephonic version of oral arguments, which has a feature of letting us actually hear from Justice Thomas, who doesn't normally talk during oral argument, but because each justice gets his or her turn now in the lineup, Justice Thomas, because of seniority, gets his questions in pretty early. And I really like hearing from him. And I really like hearing his questions. I think they're good. I'm sorry he doesn't speak at other oral argument. I think before Justice Kavanaugh joined the court, before when Justice Kennedy was still on the court, in that iteration of the court, and before that with Justice O'Connor in the same mode, briefs and arguments were tailored to get that vote, right? You needed the swing justice. So you needed the Kennedy vote, and you tailored your arguments to him. You went back to cases he had written and quoted from them and everything else. What do advocates do now, especially advocates on the liberal end of a case or the harder to make it as an originalist or textual case? It's really hard to say because in the last couple terms, the Chief Justice, for all intents and purposes, was the swing justice, a very odd concept for somebody who, as I said, is a pretty conservative guy, but his vote was available on a few things where he didn't want to move the court too fast or thought for other reasons that he was going to side with the liberals. Now, Justice Brennan used to say that the most important rule at the Supreme Court is the rule of five, and as long as you could count to five, you could get your way. Well, now conservatives can kind of count to six, so they have a spare. I would say that if you are arguing for what's understood to be the more liberal side, you had better figure out a way, and it's not going to be that easy for you, to come up with a compelling originalist argument if it's a constitutional question, or a textualist argument if it's a textual question, to make your case, because you are starting out in a huge deficit. You are starting out with 3 votes that might predictably be for a liberal outcome. And Justice Brennan could tell you, you got to get 2 more.
Well, that brings to mind, so I have started reading this book called Hamilton and the Law. So using the musical Hamilton and talking through some of that. And one of the very early, I can't remember if it's in the introduction or if it's one of the early chapters of that book, basically said Hamilton may actually recraft some of the textualist or originalist understanding by going back to his writings and the Federalist Papers and things along that line to sort of get to what may arguably be a slightly more liberal view of what the founders had thought.
There is, I mean, people should understand that there is now a sort of emerging school of liberal originalism, where people believe, and Justice Stevens did this in the gun case. He went back to, as Justice Scalia wrote in the case that found that there was an individual right to bear arms that was part of the Second Amendment, and he went back to both the history and the text and the understanding of the framers. Justice Stevens did the same exact work, and as I was saying about the Title VII case, the gay rights case, came out in entirely the opposite direction using the same set of tools.
All right, so let's take a look at some of the cases that the court will be looking at now that Justice Barrett, well, they were going to look at them anyway, but now that she's on the bench herself, may have a slightly different outcome. And I think the first one that they're slated here is, at least the first big one in my mind, is just after Election Day, and it's a religious freedom case, Fulton versus the city of Philadelphia.
So this is a case, and I hope I'm going to get this right, because I've been focused so much on the election law cases that are before the court right now, and on the election itself, that I might give a little bit of a fractured fairy tale version of this. But the fundamental question in this case has to do with the intersection of gay rights and religious rights. So Philadelphia has a rule that says that, I think it's Philadelphia, that adoption agencies have to be willing to place children with same-sex couples. A Catholic adoption agency has a long history of doing adoption services for the city of Philadelphia, but says that it can't participate in that program and place children with same-sex couples because it interferes with their religious beliefs. And so it's one of these clashes of rights that we are going to see in the next several years as we work our way through this issue in the courts and in society. A clash between the rights of gay, lesbian, transgender Americans to have equal treatment under the law as they see it, either under the Constitution or under legislation, and the rights of religious groups, religious institutions, and religious individuals to follow their faith and to not be forced to violate the tenets of their faith. We saw this a few years ago at the court with a case called Masterpiece Cake Shop. Question was, and the court didn't fully answer it in that case, kind of punted it down the road. Question was whether a baker whose religious views prevented him from supporting or endorsing same-sex marriage could be essentially forced to or driven out of business by his refusal to bake a wedding cake for a same-sex couple. We're going to find numerous ones of these clashes, and my prediction, in particular with the addition of Justice Barrett, this is a really hard and close question. In my view, there are equities on both sides, and there's a need for some accommodation on both sides. But it's clear that Justice Barrett, Justice Kavanaugh, Justice Gorsuch, Justice Thomas, the Chief Justice, Justice Alito, are all pretty heavily going to come down with their thumb on the side of religious freedom. We saw it in some cases that were decided by the court last year, and now there's a spare vote.
Well, and you mentioned some of the election related cases as well. So why don't we dip into those a little bit? So since we've already started seeing them.
Can I say one thing about one other case that's going to be argued a week after?
Of
that
course.
Before we do the election cases, which is the Affordable Care Act case.
Yes. Texas versus California and California.
I want to get this one in because Justice Barrett's position on the Affordable Care Act, or comments about it, and her role in reviewing it were made such an issue by the Democrats, completely understandably, in the confirmation hearings. I do not think that the Affordable Care Act is in jeopardy of being struck down in its entirety, nor am I convinced that Justice Barrett would be part of an effort to strike it down in its entirety. It was a good argument for Democrats because it's politically popular and it's scary to people to think it might be struck down. She did have some criticism of the Chief Justice's contortions that he went into legally in order to save the constitutionality of the law. But the fundamental question that's before the court is a question about the severability of a piece of the statute, and whether, if that part of the statute is in fact unconstitutional, whether the whole edifice comes tumbling down. It is a conservative supported doctrine to have a presumption against that outcome happening. We heard it from the Chief Justice, from Justice Kavanaugh, and from Justice Gorsuch, I think, at the end of last term. I think that predictions of the death of the Affordable Care Act are extremely premature. I'm sorry to hijack that now.
No, that's totally fine. Because actually there's then in that spirit, there's one more case I want to discuss before we get to the election cases, because I feel like the election cases will take up a lot of time. And that relates to the census. So in late November, the court will hear a case arguing that non-citizens should be excluded from the census. And so wanted to see if you had any thoughts about that one as well.
I think this case is really bogus and not a hard case for the court. The Constitution says that the census counts persons. It has been historical practice, and clearly, I think fairly clearly, the understanding of the framers and the practice of those who were there contemporaneously for the early censi, that in fact you didn't have to be a citizen to be counted in the census. They clearly knew how to say citizen when they meant citizen. They didn't. They said persons. So I think go away.
All right, we'll see.
There's also a really interesting question that I completely haven't thought through or considered about what happens if the United States switches its position in this case if President Biden takes office. There are a number of cases in which the Solicitor General's office has taken a position that it would probably abandon in a Biden administration. And so that could play into this as well.
That's true. That's a fairly common, I'm not sure we necessarily see it at the Supreme Court level, but we certainly see the Solicitor General and even the Attorney General's office working through various cases that when there's a change in administration, those priorities change. And so those cases kind of go away. All right, so let's talk about the election-related cases, because we're starting to see those already. We started seeing them before Justice Barrett was officially seated. So we had the emergency ones from Pennsylvania, North Carolina, and Wisconsin, I think so far. And I think Arizona is also in Alabama. Thank you. Yes. Also on the docket, but not scheduled. So certainly a lot of conversations about how, and I don't know if we need to take them separately or they sort of naturally flow together.
I think they naturally flow together in this way. The question is really, which is more important? hard and fast rules that are predictable and set in advance, or accommodating changes to the reality of the pandemic and the difficulties that the Postal Service has had. And layered on top of that is a question about who gets to say that. If a state legislature says, yeah, you know, pandemic, schmandemic, we don't mail out ballots, we don't provide additional drop boxes, we need to have we don't care how messed up the Postal Service might be. If it doesn't arrive by election day, tough luck. If the legislature says that, who gets to say, whoa, wait a second, there's some equities at stake here. And then within that, there's two sets of questions. One possibility is federal judges might get to say, hey, state legislature, no, you're not vindicating the right to vote. This is unfair. Clean it up, extend the time. That's what happened in the Wisconsin case, for example. The federal judge intervened. There's also a possibility, and this is what we saw in the Pennsylvania case, that a state Supreme Court can say, hey, wait a second, you know what, state legislature, we have a state constitution that says our state constitution explicitly protects the right to vote, and you are not doing enough for that. And in that case, does the state legislature does the state court get to boss around the state legislature? The reason that this matters is that the federal constitution provides some degree of protection for state legislatures to set election rules. State legislatures, kind of bossed around potentially by Congress, get to set state election rules. So there's a question about whether state judges get to intervene there, and in particular, whether federal judges get to intervene there. And that's the discussion that we've seen before the justices. For example, Justice Roberts, who voted to allow the essentially to allow the Pennsylvania State Supreme Court to boss around the Pennsylvania legislature, voted the other way when it was a federal district court that was trying to boss around the Wisconsin legislature. This is going to be, I really hope this election is not a close election. I hope we are not enmeshed in litigation. But as I know you had Ned Foley here a few weeks ago. He's been writing columns for the Washington Post that everybody should read. I've been editing them and learning a lot from them. It's a really fascinating and very up for grabs area of law. And I hope it doesn't get made too much too soon, because it would be very, very bad for the court and the country for us to find ourselves, which we could, in another Bush v. Gore situation where the question of the presidency is essentially determined by the Supreme Court.
And that is certainly, I feel like something a number of organizations and certainly the two major political parties are preparing for is November 3rd, and even down to the discussion of we must know November 3rd night, which doesn't take into consideration all of the additional counting that needs to go on. Or, is it what I always find interesting, and to be perfectly frank, I think it was Justice Kagan's comment earlier this week as well, that there are no results to flip until
Yes.
you know what the results are.
Kind of a good point. She was responding, by the way, to Justice Kavanaugh, who was writing about the important. I thought he had some reasonable points to make in his concurrence, but he argued that it's really important to have certainty on election night. This makes no sense. No results are certified on election night except by broadcast news networks and the Associated Press, and they don't have any actually electoral standing. And by the way, this is Justice Kavanaugh, who, along with the Chief Justice and Justice Barrett, was in Florida for the recount, where, as I recall, there was a lot of arguing about the importance of continuing to count votes, say the votes that were coming in from absentee ballots mailed in from overseas after Election Day. So come on, Justice Kagan had way the better of that argument.
Well, and that's, even as we learned from Ned last week in the Electoral College webinar, was that this process, the electors don't need to be certified until 36 days after, then there's that's the safe harbor period, 6 days, and then there's still 6 more days before they actually start their work. And so clearly in the Constitution, it has been designed that this is a process. And so while you certainly need to know who your electors are somewhere in that window, there's nothing that says it has to be done Election Day evening.
Right.
All right, so we're going to open it up to questions. So please, if anyone in the audience has a question, please put it in the chat on Facebook, or if you don't have a Facebook account, feel free to email it to us at info@roberthjackson.org. We do have a question from Noah, and Noah asks, if the court is seen as increasingly partisan and the country loses faith, basically, in the impartiality of their decisions, does it at that point make sense to impose term limits or some other limiting factor, or is there a better way to restore confidence in the court?
Well, I would separate out those two questions. I think it makes sense to impose term limits, period. I think that the combination of the luck of the draw nature of replacing justices, the stakes of replacing justices and the way that nominations have become more political than in the past, the fact that nominees have become more extreme and are going to be more extreme because of the absence of the filibuster, though I think I was arguing for this well before we got rid of the filibuster. It just makes, and I think I left out the most important part. People didn't live as long, okay? Nobody expected to have people on the court for 30 years. That's crazy. So I think term limits make sense in and of themselves, separate and apart from the notion of creating confidence in the court. I think the thing to me, I wrote a column about this earlier in the week. If you have a regular transition of justices, you should have a court that doesn't follow the election returns, and we don't want a court that follows the election returns. We don't want a court that's political in that sense, but we don't want a court that's too far out of sync with where the country is. And what we've had, I think, 5 of the last 12 presidents have been Democrats. In addition, Democrats have won the popular vote in 2 more of the presidential elections. So more people have voted for a Democrat than a Republican for president in 7 of the last 12 presidential elections. But during that time, as I said before, 15 of the 19 confirmations have been of Republican justices, and increasingly conservative of justices by Republican presidents, and increasingly conservative justices. So when you have a court that's skewed that way because of the kind of counter-majoritarian aspects of the Electoral College, and add on that the counter-majoritarian aspects of the Senate, you have a court that's not going to be in sync with the country, and that's going to look partisan kind of for that reason, and that's going to risk losing legitimacy. What does losing legitimacy mean? I don't really know. I think it's not good, but people are going to still follow the rules of the court. But you're going to create increasing calls for things that are more extreme and radical than term limits. And that may be kind of close to where we are. I do think that the court, the justices, some of them are, I'm thinking in particular of the Chief Justice, but also Justice Kavanaugh, are exquisitely aware of the risks to the court and are going to want to try to make sure, even with this bolstered majority, that they don't get out too far too fast. But they're going to get pretty far because as I keep saying, you only need 5.
Right. Well, and this leads me, so obviously one of the questions that has been swirling around in the news a lot is if Biden is elected next week, what does that mean for the court? And so does he explore an expansion of the court called court packing? And I am mindful of Justice Jackson's role in FDR's plan in the late 30s. And Justice Jackson had a quote, and I'm not going to remember it exactly, but that it's basically, if you try to show the public that you're trying to right the ideological beliefs of the court, that is something that they probably could get behind and understand as a need to expand the number of justices on the court. I just wanted to ask, do you have any opinions on what's floating around about court expansion and both whether that's a good thing and the likelihood of the Democrats pursuing that if they are elected?
Likelihood that some Democrats will pursue it when elected, if they're elected, likelihood that it will happen very low, I think, because this is the Democratic Party, which means that it goes from Joe Manchin to Bernie Sanders. So he is not going to be going along with that. It's going to be hard to amass a majority for it. I thought that the vice president, after he smartly ducked, but did not duck smartly initially, the question of whether he supported court packing. I kind of bristle at that term. I think that the court was packed with 2 justices who shouldn't be there, Justice Gorsuch, because the seat should have gone to Merrick Garland, and Justice Barrett, who shouldn't have been confirmed. But he's not kind of temperamentally a fan of that. He had said in the primaries that he had qualms about court packing. He eventually, after saying he was no fan of it, got himself to a better place, and the sort of more instinctive political place was, let's have a commission, which is just Washington's way of kicking a can down the road and not doing anything about the problem. I think that's actually, I know I sound a little dismissive about it. It's kind of a healthy thing, because it would be good for us to have a discussion about this, would be good for us to have a discussion about term limits and whether there's a way to achieve term limits without having to go through the hassle and kind of undoability, really, of infeasibility of a constitutional amendment. There may be some mechanisms for that. I'm pretty confident that the size of the Supreme Court will remain at 9 for the foreseeable future.
We're also getting a couple of questions with regard to human rights or social justice decisions, and curiosity whether or not those have largely come under liberal courts. And so specifically, they mentioned Brown versus the Board of Education, and these questions came from Ida and Jeff. So one was asking, have mostly pro-human rights decisions been decided while you would have considered the court a liberal court? And then similarly, social justice decisions.
Well, so Brown, let's remember, was a unanimous decision that was crafted by Chief Justice Warren, who I feel like the way President Trump talks about Abraham Lincoln. Did you know he was a Republican? I mean, Earl Warren was nominated to the court by President Eisenhower, turned out to be the leader of the liberal Warren court. But that tells you, that's sort of an example of what we've been talking about changing times and people being surprises. So that was a decision that was unanimous. And so that takes justices of all stripes. If you look at, when you talk about decisions relating to human rights, the first thing in recent times, the first thing that comes to my mind is Obergefell. The gay marriage decision, that's a decision that was authored by, and the intellectual framework for it and the presidential framework for it was laid by Justice Kennedy, nominated by President Reagan, after Bork, by the way, failed. And so they are decisions that have come from courts with enough liberals to support them, but that have included otherwise conservative justices. I mean, I don't know if you would take the Bostock decision, which is the Title VII decision on gay rights this last term, as a human rights decision, because it's about, in part because it's interpreting legislation. But if you do, that had 2 Republican votes, the Chief Justice and Justice Gorsuch. I do think that let me keep going. Roe v. Wade, if you see that as a human, I understand that there are a lot of people in good faith who believe that human life begins at conception and that this decision allowed the taking of a lot of innocent life. But if you look at Roe, as I would, as a human rights decision that allowed women to control their reproductive freedom, that was a 7-2 decision. One of the 2 dissenters was Byron White, a John F. Kennedy appointee. It took all sorts to get that ruling done. That said, we are not going to see another Obergefell. We are not going to see another Roe. The more salient question for right now is the extent to which we're going to see their undoing.
Gotcha. Okay. Ruth, that is the end of our questions for today. I really want to thank you for being with us. I also want to mention to the audience that we will be having tea again in 2 weeks on November 12th. Our guest will be Rebecca Coakley. She is the director of the Disability Justice Initiative for the Center for American Progress, and looking forward to that conversation. And you can, if you weren't able to tune into this live or you have friends who have missed it, please let them know they can catch it on our Facebook page or on our YouTube channel starting tomorrow. And look forward to seeing all of you again in 2 weeks. Ruth, thank you so very much.
Thanks so much. I really had a great time. Thanks for having me.